Hi everybody, I'm Bill Clark, Policy Director for Washington Realtors, and I wanted to give you all an update on the Hirst Decision, which is the state Supreme Court decision that affects water availability in many parts of Washington. As many of you have heard about, in October of 2016, the state Supreme Court issued a decision called Hirst that related to the ability to use new single private wells to build new homes. What the court ruled in that decision was that even though Ecology, Department of Ecology, which is our state's water resource agency, has adopted a regulation at the local level that allows new wells to be drilled, that under the Growth Management Act, counties have to review each new well for impairment or impact to in-stream flows. What that means is that counties can no longer rely on regulations adopted by Department of Ecology. They actually have to exceed those standards. It's fair to say that that decision has caused nothing short of chaos in many counties throughout the state. The case came out of Whatcom County, but it affects many other counties that are both planning under the Growth Management Act and that have in-stream flow rules, which are environmental regulations dealing with water that are adopted by Department of Ecology. At this point in time, even 3 or 4 months after the decision, many counties are still struggling to understand what the decision even means and how they can implement it and whether it even can be implemented under existing water law. As the legislature started in January, it's been one of the top issues in the housing area. And at this point, there's a Senate bill, which is Senate Bill 5239, sponsored by Senator Judy Warnick from Moses Lake, that passed the Senate a few weeks ago, and now it's over in the House committee. It was heard in the House Agriculture and Natural Resource Committee. It was not yet voted out. You know, typically during a legislative session, if bills don't make it out of committee by a certain date, they're considered dead because they haven't passed by a certain deadline. But this bill is so important and the impacts of this issue could be so severe if the legislature does not clarify the case that I think it's fair to say that the bill is probably not subject to those deadlines, and it is likely going to see continued work through the very end of the session, probably up until the time that the legislature adopts the final budget. The thing to keep in mind is what we're focusing on for Washington Realtors, working closely with home builders and counties, is to make sure that county decisions can rely on rules that have been adopted by Department of Ecology. That is, the reality is, even though we may not love Ecology's regulations, they are in fact the state's water resource agency. Once they adopt a regulation, that provides certainty, and counties and landowners and home builders and realtors should be able to rely on those regulations. What we're trying to make sure doesn't happen is that when there is an ecology regulation, that counties have to go beyond that regulation and have their own independent review of groundwater impacts or impairment before someone can get a building permit. We've had a great level of interest from our members, from local associations, and from landowners who have come to the hearings, who've called their legislators, and we need to keep that up through the rest of the session so that the legislators, both House and Senate, Democratic and Republican, understand the importance of this decision and clarifying the Hirst decision so that we can have homes built in rural areas. Thanks for watching, and thanks for being a member of Washington Realtors.